Edit audio.
Hello, everyone. I'm Robin Hopkins, and this is Well Adjusting, where I talk to people about life stuff, but not in an NPR way. It's more like we're at the bar, having cocktails, getting into your business sort of way.
It's giving drunk NPR.
Oh, and producer Steph is here too.
Hello.
Today we chat, well, getting your shit together for the unthinkable, part 3. Hello, everybody. Welcome back to our conversation about everything you ever wanted to know about preparing for death. Yours, your loved ones, all the people who are about to die. Yes, that's weird and dark. I understand that. Now, as y'all know, or should know if you've been listening to this series, and if you haven't, go back 2 episodes. This is a 3-part series. Today is our final episode in the series, and we are focusing on the financial side of things. Okay, now we kicked this series off 2 weeks ago with Jorge, who is worried about helping his parents as they age and the burden it might put on his partner. And we offered some solutions there. And then last week, we talked to Chanel Reynolds, founder of Get Your Shit Together, who walked us through the emotional barriers to starting the process. She also gave us all the helpful checklists of what you should have squared away for the unthinkable. I mean, both are incredibly important episodes, so if you missed them, head on back. But today, I'm excited that we have Byron here from Scrivener, and he's going to be talking to us about the financial side of things. Everything from trusts to probate. And if you don't know what those words are, don't worry, you are in the right place. We got you. The whole goal in this series is to make hard situations a little bit easier. So without further ado, let's get to Byron. Well, hello, Byron. Thank you for joining us today.
Well, thanks, Robin. Happy to be here.
Before we get into I start firing 1,000 questions at you, can you just tell us a little bit about yourself and how did you get into this work? Because weren't you a financial, an impressive title that I can't recall?
Yeah, so I think it sounds more impressive than it might be. So I'm a certified financial planner. No, actually, it's
That's impressive.
Very big deal. Most financial advisors aren't that. And so 2012, so well into my career as a financial advisor, my wife's grandmother passes away and she names me the executor and me the trustee. And so then now I'm in the doing. And, let me just tell you, that's a really hard task for anybody to do.
Yeah.
On the one hand, you got the legal paperwork side. On the other hand, frankly, you got the family drama. That's always the family drama that makes it hard. And so for reasons that we don't have time to get into, the attorney who drafted the documents really messed up. And I had to probate that estate. There was not a lot of money. There was assets for sure. So I instantly became the landlord of 12 apartment buildings. There was a restaurant at the bottom floor, plus the house. So I had to manage the estate, the family issues, plus the building. And so that was my experience becoming a executor and trustee. And so I mentioned the document was wrong and I really disliked the attorney. So I didn't use that attorney. So probated the estate without an attorney, which is kind of like doing electrical work at the panel on your own, right? Some people can change light bulbs. A crazy person like myself likes to go into the electrical panel and do it themselves. So definitely not.
By the way, Well Adjusting is not telling you to do that, by the by.
Oh, I should give a disclaimer. This isn't legal advice. Side note, when somebody is creating these documents, the person that they nominate is never consulted. Was I ever consulted about what was in the document? No. No one is ever consulted.
Yeah, that's true. They're just you're my executor.
And you're the one that has to then, execute it, right? And so that was my kind of start point. And because I was a financial advisor, I had clients who were dying and their family members coming to me, hey, so-and-so died. What do I do? So many stories, but essentially I just had an ear for the need of people to have some better process to probate an estate. So I launched Easy Probate, which was then the first do-it-yourself without an attorney probate system. And so the idea was really simple.
Wait, before you go into that, can you probate for dummies? I've heard that word thrown around so many times. Not exactly sure what it means.
All right. So at its basic level, probate means to prove. So it's Latin to prove. So what is it that you're proving? So probate court is the court and the process where you would prove a will valid if one exists, and then you would prove who the heirs are if a will doesn't exist. So let's kind of even super
So it's
basic.
like a checks and balances on wills, essentially.
Yeah, for sure. And also if there is no will. So testate means testamentary, so there's a will. Intestate means no will. So if you die intestate without a will, right? So the question is, well, who should be in charge? Because no one is nominated. There is no will. And who should inherit? And so the law dictates who should be in charge and who would inherit. It's basically next of kin, so it's not overly complicated. So if there's a spouse, if children, and so on. If there's a
that's
will,
state by state, right? Not
it's
federally.
pretty universal. I mean, think about it this way: like the closest next of kin is who will inherit if there is no will, and they have priority to be the administrator, person in charge. And so almost universally, it's the same. Will certain states have certain percentages different than others? 100%.
Yeah.
But so then if there's a will, you have to prove it valid. How do you prove it valid? It's really not as fun as you think. It's the lack of objections. So imagine we're all siblings. Mom dies, we're all siblings. I present a will. If, Robin, you think that will is invalid, you have to challenge it. If it is valid, if you think it is valid and nobody challenges it, well, then the court's going to be like, great, we accept it. So it's not this like, the court doesn't assign a private investigator. They are relying on
It's just if
people.
some animal from your family comes up and is like, I want that money, essentially.
And listen, there are times where you should challenge a will. You should challenge the petitioner. So what makes a will valid? It has to be signed by the person who, made it. So the testator has to be signed. So you could challenge on the grounds of it was forged. The person has to be of sound mind and not coerced. So again, you can challenge it on the basis of, hey, the grandma had dementia. There's no way she would have been able to sign.
Right.
You have to prove it, though. You can't just claim it. And then there has to be the required number of witnesses. Typically, universally, it's 2. You never require a notary, by the way. No state really has a notary requirement. So there's usually 2 witnesses signed and not coerced and of sound mind. So that's what makes a valid will. And so what is it that you're trying to do when you do probate? You're trying to transfer the assets from the person who died to the rightful heirs and then settle their affairs, i.e., debts, creditors, that kind of stuff, and close their bank accounts, businesses if they have one. So it's really the process of transferring the assets and settling the affairs after someone dies.
And I always hear about it taking like a year. Is that standard? Like that it takes to like get through the whole thing?
Yes and no. So let's figure out what standard is. So most states don't require you to have an attorney. So there are people who can do it on their own without an attorney. The reason I bring that up is, in my experience, and this is not universal, I should say, but in my experience, the thing that takes the longest is the attorney. On average, it takes about 3 months from when you contact a traditional attorney and they will then actually file. Some states, which is, let's see if I can remember off the top of my head, it's going to be Texas, Florida, Missouri, Iowa. I'm missing one. It'll come to me. There's like 5 states that require by law an attorney. And so luckily, not every state. A few counties like Cook County, which is Chicago, no judge will approve you if you don't have an attorney. So there are these like weird county rules. Think of judges as kings and they have the little kingdom. They get to make their own rules. So it is really bizarre. And so most people can't do this on their own. And also typically they're pretty emotional. Somebody they love just died. And, that's not an easy thing to just start doing the paperwork. So it's kind of like doing your taxes. Imagine your wife dies and now you got to do your taxes. That's kind of what you're faced up against. And so if you use an attorney, then they tend to do these things for you. But they're not going to call the bank for you, nor would you want them because they're charging you $500 an hour. Every time they think about you, answer an email, that's a billable hour.
Hey friend, I'm just jumping in here to say that we've got a new way to get in touch with us. If you want to leave us some feedback, hopefully good, or suggest an episode topic or ask a question, all you have to do is go to sayhi.chat/welladjusting. The link's in the show notes, but I'll say it one more time. sayhi.chat/welladjusting. You could leave us a voice memo and we might just use it on air. And if you happen to be enjoying this episode, why not go ahead and subscribe to the podcast or rate and review us? You won't regret it, folks.
The next obstacle that people face is payment. I don't know if you've ever hired an attorney, but generally speaking, attorneys don't do work unless you pay them upfront a retainer. And the typical retainer for most families, or for most cases, is about $5,000.
Jeez.
And that is beyond the reach.
Can that come out of the estate or no?
The estate doesn't exist yet. Remember, you have to do, it's a chicken and the egg. What comes first? The chicken or the egg?
And because they're dead, you can't just write a check off of their checking.
You don't have access to the account, correct?
Right.
That's the whole point. So here's some not so fun stats. Roughly 50% of U.S. adults don't have $1,000 at the ready to pay for an unexpected expense.
Ugh.
About 70% of U.S. adults don't have $5,000 at the ready. You might have $5,000 in 401k. You might have $5,000 value in your car or in your house,
cash.
But you don't have liquid cash. Exactly. 70% don't have that. That's your typical expense. On a very normal, not always, but the normal cost of probate to start a case can be up to $10,000. So now you're only talking about 92% of U.S. adults don't have $10,000 at the ready. So those are the challenges that people face.
So, okay, I already feel there's going to be like so much to talk about, but like, let's say, what's the for dummies? This whole thing, I'm just going to keep saying for dummies, me and Steph. What's the process? All
right, so let's just take a traditional hypothetical example. We're all siblings. First, let's analyze dad dying, mom still alive. So most couples will own things jointly with rights of survivor, right? It's not always the case. And so if mom and dad own things jointly with rights of survivor, dad's death likely doesn't trigger much for us, right? Which is kind of how you get lulled into thinking, oh, I don't have to do anything. Dad
Easy
died.
peasy.
It was super easy. Yeah.
Yeah.
So that dad dies, mom has access to the bank account, everything transfers to her. Again, virtually nothing we had to do. Okay, so now mom dies. The first thing that would happen is what? We would likely do a funeral and cremation. And so this is the first time you're hit with, oh, shoot, I personally have to come up with the money to pay for the funeral. They're not going to bury mom unless they get paid. So we all are going to have the conversation. Oh, hey, funeral is X. And so think of the funeral as two parts. There's the actual burial, and then there's the ceremonial celebrations. The reason I say that in two parts is most states have a law that says the funeral is a required reimbursement from the estate. Think of funeral as in burying and or cremation, not the party. So if we have a party.
Well, Steph's going to pay for the party in our family. So I feel like that's really a good start. But we can't get the money back on the party.
Well, unless we all agree to, right? If all of a sudden I'm a jerk and I'm like, no, I never agreed to this. So now imagine a different scenario where mom had remarried and now the surviving remarried husband, not our father, is the one in charge and throwing the party. We might have feelings about it. So you can quickly see how it can get complicated as family dynamics change. All right, let's go back to the vanilla example because we can go down to too many rabbit holes. So the first thing we got to do is figure out how we're going to bury mom. The next thing we're going to be like, oh, mom had a financial advisor. Let's call the financial advisor and use mom's money, for the funeral. And that's typically when you're first going to learn the term probate. So you call the bank, you call the financial advisor. You're like, yo, mom died. I need help. I know she had $50,000. Can we use some of that for the funeral? And then you're going to hear, sorry, we can't help you. You don't have authority to access the account.
This is horrible, Byron. But could you, and I am not advocating this, just not tell the financial advisor that they died and take a $10,000 withdrawal and then tell them a week later?
All right. So
Can you tell my dad was a used car salesman?
I was thinking the same thing. I was like, well, you could do that.
So you're describing one of the most common situations, right? So let's talk about access. So there's legal access. I am an account holder, or maybe I have power of attorney, or maybe I have check writing privileges, right? Or maybe there's a transfer and death designation. And so what often happens, especially with families that are relatively tight, Robin, you might have had mom's password because mom was terrible with computers, right? And so many people have, I'm going to use the word informal access to the account. So if you can get your hands on it, if you could write a check and the bank doesn't know that mom died, they will honor that check. And so, yes, that does happen.
Okay.
Right. But now sometimes the opposite is true. Mom was super private, didn't share. We might not even know where the bank account is, which institution. So a little bit of both. So if you had informal access, is it technically allowed? The answer is no. Do they prosecute you? Of course not. Like, first of all, no one's going to know unless there's a fight amongst the family. Then somebody might challenge it in court. But usually, the informal access is pretty common.
Okay, great. Keep going from there. So,
all right. So now we're at the funeral. So everybody's sad. We're burying mom. Everybody gives us, our condolences. And then all of a sudden, well, guess what? Mom died maybe a week or two ago. Guess what typically happens first of the month? The bills come.
Oh, the bills.
The mortgage comes. And what if mom was ill for a long time and we were so busy dealing with the illness of mom, nobody bothered to check if mom was paying her mortgage. And so maybe the first thing that we get is a letter from the bank saying, hey, mom hasn't paid the mortgage for 6, 5, 10, 12, whatever months. And there's a notice that the bank is going to sell the house unless we pay what's owed. So that you can see how often these financial situations really escalate. Now, if we were level-headed and had ample time, because Robin, I don't want to assume, but I know you have a job, so you probably are working 9 to 5. Steph, you're busy producing podcasts, and I am a financial advisor. And at the time, when I was the executor, I was also the Cub Scout leader. I was the basketball coach. So before you know it, now
you got a part-time job too.
It's forget part-time. It's like 2 full-time jobs. And so then all of a sudden it's like, oh shoot, we gotta really mobilize. And we haven't even buried mom yet, or we just buried mom. And if we are in an emotional state where we can't handle this and we just stick our head in the sand, like, oh, I'm not opening that letter, it can really escalate. So these are the typical problems. Okay, so let's go back to the vanilla example. So now we bury mom. We start rummaging through her mail to look to see what assets we have. We go into the house to find if there's a will. Most people don't know who their parents' professionals are. And so as we are...
The guy who did our will is not alive any longer. So it's like...
so common.
Yeah.
It's so common for the attorney to be dead by the time we need their help. So now it's like a scavenger hunt. What can we find in the house to give us clues of what mom or dad had, right? And so now we start building the picture of what assets they had, what creditors they had, but we don't know what to do. And so now we get stuck. We're like, we need the money. We don't have access to it. Most income will stop at death, right? And so how are we filling up mom's bank account to pay for the mortgage, to pay for the bills? So even if you had informal access, it eventually will go away because most people don't have, that much money in their just a plain vanilla checking account. So now that's when we typically will be like, oh shoot, we need professional help. And now we're either going to get an attorney. Maybe we talk to our accountant. Maybe we talk to somebody who we knew a couple of years ago was the executor to give us advice. So that's usually how people will end up in the situation where they are either looking for help or there's an emergency like a foreclosure where they need immediate and instant action because sometimes people find out, oh, wow, the bank is selling mom's house this Friday.
Jesus. So if that's not the case, that's awful, by the way. I would never even have occurred to me. But you're right, though, like when people are sick, like things just go by the wayside or if there's like dementia or whatever. But in the case, let's just say best case scenario, they were in good shape, bills were being paid, you know where things are. Is it best in that instance to just go it alone to save the attorney money? Is that like up to your capabilities? Is that...
Really depends. Let's go over the options. So what are your options if someone passes away, you need help with probate? Obviously, you can do all the research yourself, which would be contacting the local probate court and seeing if you can get documents for free by them. So, for example, I live in Vermont. Vermont is a super cute little place, 600,000 people max. So everybody's super nice. If I were to walk to the Chittenden County clerk and ask them, hey, I need probate document, they would give me all the documents with a little booklet that says, here you go. And the forms are super easy. So easy. Let's compare and contrast California. California, the forms are so complicated. At least they're available online. So it's not like you couldn't figure out which forms. But when you look at it, you'd be like, I have no idea what it says. So let's just say we just wing it. We fill it out and we file it. Well, now it goes in front of a judge, and the judge either approves it or denies it, right? And so if they deny it, sometimes they tell you why they deny it, sometimes they don't. And so now you're like, I don't.
Why would you not tell a person why? That's insanity.
It's probate court. And so it gets really complicated fast. So can people do it themselves? Of course they can. Depends on where you live and how complicated the individual probate state might be. But also, your individual ability and or emotional state. Okay, so option 2 is to hire an attorney. Again, I would say on average, you're looking at about $10,000 total cost from the attorney for it all, assuming there's no fighting. Okay, so then what's option 3? Option 3, I'm going to say some version of help that's non-attorney led. So for example, there's a book out there called How to Probate an Estate in California or something like that. So if you want to read it, it gives you the forms. I mean, you can get really good help. Now, granted, that's a lot of your time.
Yeah.
Obviously, I created Easy Probate. So that was the first kind of online do-it-yourself. And there has been others. So you can Google probate help online DIY, something like that. And there's going to be some various degree of options to help you. I'll explain how our company works because we kind of are in the middle. And so what Scrivener does is we offer a guided solution where we can help you, walk you through probate step by step, fill out all the forms for you, start to finish for a flat fee of $3,000. If you want an attorney, we can provide that attorney. We have a nationwide attorney network.
That's awesome.
And there are times where some family members or situations, they don't want to do anything. And so we can be nominated as a professional fiduciary. And so now, why do we even exist? Because all of that you can find to some degree elsewhere. We exist because if you don't have the money up front, we don't turn you down. We will essentially finance it. We will pay for all the expenses up front to get an attorney, do the court fees, do the newspaper announcement, get a fiduciary bond. And what we specialize in is stopping foreclosures due to death. So if you want help, we can provide it. And if you don't have the funds, we can help you.
So Scrivener's like the hybrid.
Correct.
Okay. I love it. Okay. So let's come off probate because it's like there is so much to talk about. And let's look at it from, say,
before you ask your next question, let me just ask
Okay.
what the original question was. How long does it take?
yeah. Oh, yeah.
I would say on average, a normal person who gets an attorney and does it through the process, they're probably looking at 18 months, start to finish, before probate is over.
Wow.
And the prototypical, how fast could you do it? Let's just say we did everything as fast as possible. In theory, you can get it done in 6 months to 9 months in most states. So you're probably spending twice as long, very often, waiting for the attorney to do the thing you've asked them to do.
Yeah. Oof. All right. So given all of that background, let's start with how you would set yourself up, like financially, so that, let's say you're me and Steph's dad, so that you make it as easy for Steph and I as possible. Or if we're the kids and we want to go to our parents and we want to be like, you got to get your shit together because otherwise you're leaving us with all of this. So where would you start? How do you start? And what do you tell people to do?
100%. So this is what's called estate planning. And so that's a broad term. I would say estate planning is the following. Estate plan is going to create a path that will transfer the assets after I die and assign somebody to be in charge with as little effort as possible. There are really 3 ways to avoid probate. There's what we call statutory transfers. Remember the example where mom and dad are married, own things jointly with rights of survivor? Boom. One of them dies, the other instantly owns it. Technically, that's an estate plan, right? The title in the deed, the title in the bank account dictates it. Okay. Second way you can avoid probate is by beneficiary designations. So that's your 401k. That is your life insurance, those kind of things. Now, mind you, the person that's beneficiary has to be alive. So many, many times you have spouse as a beneficiary and they die first. So boom, all of a sudden that's a trap, or that's a pitfall, I should say. The third way to avoid probate would be by contract/document, i.e. trust. Yeah. So most planners would recommend most people to consider having a revocable trust. There's 2 types of trust, revocable and irrevocable. let's explain the difference really quickly.
Please. Because I think everyone thinks trust. They think of like a rich kid whose parents have money and they can't get it until they're 35 because they smoked too much pot in high school.
Yeah, there's plenty of those examples, right? And so a revocable trust is one that the person who drafts, so imagine I'm the parent here, and you're the children. So I will draft a trust that says, I, Byron, during my life, retain full access to all the money, blah, blah, blah. And then upon my death, I want to create a trust for Robin and Steph's benefit. And so as soon as I die, and here's the key, if my trust owns the assets. So not only do I have to create the trust, then I have to go to my banker, I have to change the deed of my house, I have to do all these proactive things to put the money into the trust. So not so fun fact, 70% of all trusts literally go unfunded, as in nothing ever has happened.
Literally, my uncle created a trust and never put any of the assets into the trust. And like we said to the lawyer, we were like, so you set that up, why was that? And she was like, well, we were like, how did he not know to put the things in the trust?
It's a simple thing, and this is one of those weird things as whose fault is it? Is it the attorney's fault? Not really. They probably told the client. I mean, it's tough, right? So
I like to blame the attorney. Sorry.
So if nothing is in the trust is an expensive stack of papers that did nothing. If the trust then owns the assets, then the next person, the successor trustee, can very easily, without court involvement, become the person in charge of the trust and act. Now, mind you, they have the power to act. That doesn't mean that drama, accusations, fraud doesn't happen, right? A trust doesn't solve the human problem. It can certainly solve the initial
probate
court problem. Yeah, exactly. Yeah. So those are the three ways to do it. I forgot to mention that you can also do like a quasi-beneficiary. So you can do what's called a transfer on death. You can do that with bank accounts, brokerage accounts, even deeds. You can have a transfer on death, and that will avoid probate. And so the simpler it is, the less complicated of situations it would solve. A trust tends to solve most problems because it has all these contingencies. Like, well, what if all my children die and my wife and I die? Well, then who do I want it? Well, in my situation, I named my nieces and nephews. Yeah. So you can definitely have all these contingency plans. So a trust is that's
a revocable trust. What was the difference with it? Irrevocable?
Remember, revocable means I can change it. So while I'm alive, it doesn't affect me. There's no difference. And irrevocable is I can't change it. Typically, irrevocable strategies are for like super rich tax planning purposes. And so you mentioned earlier that most people think of a trust as for the rich. Why is that? Think of this as not benefiting me while I'm alive. It's going to cost $5,000 to $10,000 for an attorney. So I got to write a check to have something that benefits somebody else while I'm dead. So most people back in the day would only, the only people who ever had a trust were, pretty wealthy because A, you had to have the money to do it. And then number two, you kind of had to have that, not that the wealthy necessarily do this, but that thought about the next generation, right? Most trusts, in my opinion, are actually written because they want to save taxes. So estate planning nowadays can be as inexpensive as $150 for an online revocable trust. Really important for this to be hitting home, which is if you use one of these do-it-yourself or limited kind of attorney-led, you got to understand what you're getting. Yeah. You are not getting a solve every problem that could ever possibly exist. You're really getting is, I want to avoid probate. Most online do-it-yourself situations, if your only goal is adult parents want to inherit to adult children, 100%, it's rare for it to not go well other than not funding the trust. Once you start getting into some complications, then you start to think about needing an attorney. Off the top of my head, these are typically the situations that we would recommend an attorney. You're over the threshold of estate tax. That threshold right now, I don't remember the exact numbers. It's basically $15 million. You got to be rich as F to even worry about this. You have a blended family or you have multiple children from different partners. At least you should think about it because now you start to divide, well, these are my assets and it can get a little tricky. So children from multiple partners, you own a business. If you die with your business and your wife is then now the de facto owner, guess what? Your business partner is now partners with your wife. Is that what you really want? And so most people need some kind of what we call a buy-sell agreement. And they need some strategy to, if a disaster happens, death or disability. Side note, you're more likely to be disabled unexpectedly than die unexpectedly. If you have any special need heirs, like how independent will they be? So a special needs trust is going to be one when an attorney likely is going to be required. Those are some common ones where people would likely need advice. But again, if you only need to avoid probate, and then these DIY, do-it-yourself online versions typically are pretty good.
What about, because we have a lot of people in our audience that are non-traditional families, whether they're like queer or maybe you're a single person who you had that SVP job, but you didn't get married and you want to leave things to your friends. Like, what about those kinds of situations? Again, it seems like it'd be like legal.
Yeah. If you're a spouse, you get certain rights. You get certain inheritance rights, even if there's no will. But a lot of people don't get married and have kids, right? Or they have non-traditional relationships. And so the only way you can direct somebody who's not blood related as an immediate family member to inherit from you is to have a document. The minimum thing you need is to have a will. That is super easy. I could write a will right now. And all that is needed to be valid, it could be my handwriting. I have to be of sound mind. I have to sign it. And if I handwrite it, you don't need the two witnesses. So if somebody wanted to, think how hard it is to prove that somebody typed the document and I signed it. So, but a handwritten will, as in the entire thing is handwritten, technically it's called the holographic will. That simply on its own is a legit will, valid. Doesn't need witnesses. So somebody could handwrite their will, boom, they're done. So if you have a valid will, so either handwritten or typed up, signed with two witnesses, now you can dictate who would inherit from you. Very important also, if you have minor kids, that's how you can determine who the guardians might be. And then obviously a trust, like I mentioned earlier, will always work. If the assets are in it, you can then determine who will be the beneficiaries of the trust, and then who would be in charge of the trust, which is called a trustee.
I'm thinking about the finances of all of this, right? Like you're talking, you said $5,000 to $10,000 on the lawyer funeral costs, which I mean, I don't know why a pine box costs so much, but it seems to cost a lot. So it sounds like you're in for like 20 grand, right out of the gate. Is there a way if I want to make sure my kids don't have to try to pony that up? Like, I don't want to give them $20,000 because then what if they turn out to be little shits and they're like, I spent it. They're not going to be. You guys are lovely. I love you both. But you know what I mean? Like, how do you make sure that that's set aside for that?
Yeah, so there are like insurance policies. You can get burial kind of insurance.
Oh, there is? I didn't know that.
Yeah, and very inexpensive. I mean, the younger you are, when you start them, the better. And so that's one way to do it. Other way to have some savings accounts that they have access to. But most people typically are going to rely on their own wealth to pay for their own funeral, as long as the family members can have easy access to it. That's going to be pretty critical.
Steph, do you have stuff in the process?
I'm so stressed.
She's so scared right now. I feel like that's one of my questions is like, for young people who are listening, I think that all this could sound so overwhelming that you might just go like, boop, boop, does not compute, shut down the computer, and then go take a nap. And how do we not scare the pants off our listeners?
Like, give me like the ABC. So like, if today I leave this recording, I go throw up and cry, and then I'm like, okay, I should get my shit together. Yeah. What are my 1, 2, 3s that I should do? My ABCs.
Sure. So what's the most likely thing that will affect you is if your parent or sibling or close relative dies, and you're the poor schmo that they chose to do all this. Right. So what I would recommend is you start having these conversations. It's like, hey, just had an interesting talk with Byron, the foremost expert in probate. And he talked all this stuff and really worried me, Mom, Dad, like, I would love to know, like, what's your plan?
Oh, lucky for me, I've been having
She's
these
been trying
conversations
for years.
Now, as far as dealing with your own items, Yeah, you should at minimum have a will. Like I mentioned earlier, if you were to handwrite a will today, you are done. You at least have who should be in charge and who should inherit. If you have bank accounts, you can add transfer and death designation to them. Instantly, that'll transfer to somebody else. If you own real estate, this is a little tricky. You should probably get a trust or do a transfer and death deed. Either one requires a fair amount of effort. So I would say the house is usually the thing that is the hardest to get rid of because there's no easy fix. But transfer and death, make sure you have your beneficiaries lined up if you have life insurance or retirement plans. And then at least
or even like 401ks, like how many times you set that shit up through your employer and then you go and look and you had never set up a beneficiary.
Yeah.
Anytime I go into those, I try to check them because it's like, I just found one like 6 months ago. We like didn't have secondary beneficiaries or something. It was just like crazy talk.
Yeah. Well, this is something that will blow your mind. Have you guys ever looked at unclaimed property for yourselves?
Yes.
No, what's that?
All right. So unclaimed property is when you have an account that kind of goes dormant or the check that never got to you. And so the state kind of safe keeps it for you until you claim it. So they never steal it. They don't keep it, but they safe keep it. And so there's something like, I want to say it's $90 billion across the United States of unclaimed property. I'm about to give you what's called the Byron stat. I can't prove this is true, but I have a lot
you
of
feel it in your heart
with experience. I would argue that 70 to 80% of that number is because someone died.
Oh.
And the only way you can give to charity if you die is to have it written down, because there's no way to give to charity if there's no will, if there's no trust, because then only the heirs next of kin will inherit. It is too easy to forget about, your 401k that you left 2 companies ago. It's too easy to, not check for unclaimed. So really have your stuff together, your shit together, start making a list and think about ways that you can easily, safely share your information with others.
Yeah. Well, and that's for anyone who hasn't listened to episode 2 with Chanel, go back because we're talking a lot about that kind of stuff too in that episode.
Yeah.
Any last hopeful thoughts?
Don't be afraid to talk about money, death with your kids, because you don't want to repeat the same thing that others have done for us, So I would say really just have those open conversations with your partner, spouse, children, if you have them, or, whoever you love. And then my last thought is a really good estate plan needs to answer 3 questions. Who do you love? What are you afraid of? And how do you want to be remembered?
I wish everyone in the audience could see how scared Steph's face looks right now.
Like, oh my God, I don't know the
She's
answers.
like, I can't forget it. Okay, say it one more time. Who do you love?
So who do you love is who's going to benefit. What are you afraid of? Are there contingencies you need to plan for? And then how do you want to be remembered? Like, is there a legacy? Is there charity? Is there, because, sometimes when you die, you leave people a mess. Yes, they might have loved you, but they're going to be like, God damn it. Every time they think about you, they're kind of grinning their teeth and be like, F&A, there was a huge mess I had to clean up.
Yeah.
And so, that could mean a lot of different things, but I think those are the 3 things I would have people think about.
I don't have a will because I'm terrified I'm going to write something in the will that's going to fuck someone over. Because I don't know my legal rights, but I'm like, if the will is just like in the best case scenario, this is where everything goes.
Yeah. So maybe we can prove in the last few minutes, just some common misconceptions, right? So first misconception is that if you are nominated the executor, you're required to do it. You can be like, no, thank you, right? And you're not obligated to do it. Second misconception is that somebody who's going to inherits your debts too. Only the estate can pay debts. Like, I am not personally responsible. Right? So let's just say my dad passes away and has $100,000 in the bank, but $300,000 in debts. I don't owe $200,000.
Like the collectors will duke it out, and then
they might yell at you and try to illegally tell you that you owe them, but you don't. Like, you're not responsible for somebody else's debts. We get this call all the time. So-and-so died. They have no money. All that is credit cards. Do I have to do anything? We just tell them, nope, you're not legally required to probate their estate. Now, some people feel the moral obligation to do it. That's fine, but you're not required to do it.
Wild.
And so
you could just send all those people the certificate of death and then be done with it.
you don't have to do anything. You can just be like, not my problem. I'm going to.
Because they're dead. So what are they going to do? Like fuck over their credit? Like,
yeah, exactly. Probably the only thing that I would kind of mention to people, especially if you're young, it is really hard to get access to the place that you live without some documentation. We had a case where somebody died in the apartment, and we had to essentially get an order to open the apartment up. And so you can leave a problem behind if you don't have the bare minimum. And the bare minimum is a will. It could literally take you 5 minutes. Like, I, Byron, give everything to so-and-so, and I leave so-and-so as the executor. It could just be that simple. And then you've authorized somebody to act in your behalf once you're dead. This can be a lot simpler than people make it out to be. But obviously, it is death. It is family. And therefore, it typically is complicated. Yeah.
Yeah.
It's just such a common situation to avoid the problem versus like, hey, let's just sit down, talk about it, make a decision. Because guess what? You can always change your mind.
Byron, you are an absolute joy. I mean, I like, seriously, thank you so much, because this is like overwhelming. And I feel like you broke it down in a really palatable way for people. I would love for you to just say the names of the two companies one more time, just so you can offer that resource. And folks, it will be in the show notes, but I want you to give out that information as well.
Sure. So Scrivener is our company name. Scrivener spelled SCRIVNR. So Scrivener.com. We help people with probate, and we also do estate planning. The two companies that we use for our estate planning is Good Trust and then Legato. That's spelled LEGATO, Legato. And so we can offer an estate plan for as little as $150. And also we can provide an attorney, whether it's probate or estate planning, if your situation really calls or you really want an attorney.
One-stop shop.
Yeah, exactly. As much help as you want from us, we can provide.
That's amazing. That is so great.
Cool.
Well, folks, that is a wrap on our Getting Your Shit Together for the Unthinkable series. Woo, was that a journey? I got to tell you, we hope that you feel more informed and not wildly overwhelmed. We hope that this has been as valuable a resource to you as it has been to us, because, I mean, I got a lot of stuff to go do now. So I want to thank Byron from Scrivener for, breaking down the definition of absolutely everything today. All of his resources that he mentioned, like Scrivener and Easy Probate, those are in the show notes. But I also have to say thank you to Jorge for getting this whole thing started. And of course, to Chanel from Get Your Shit Together. Her info is also in the show notes. So folks, now is your time to shine. Head on out there and get your shit together. You got this. For more Robin, and you may need that, you probably don't need it, but like if you do, you can follow me at Real Rob Hops on all the platforms, all the socials, as the kids today say. Well Adjusting is an Edit Audio original series. It's exec produced by Steph Colburn and Robin Hopkins. Our producer and editor is Maria Passingham, and our production manager is Kathleen Speckert. Thank you to the entire Edit Audio team and to you for listening. Oh, hey, before you take out those AirPods, this show is just for entertainment. If you are in need of help, please, please, please reach out to a professional. Go ahead and get that help. You deserve it.